Good afternoon, everyone, and welcome to 3PB's second Covid-19 Employment and Discrimination Law webinar. My name is Craig Ludlow, and I'm the head of the Employment and Discrimination Law team at 3PB. I'm joined again today by my brilliant colleague in Chambers, Sarah Bowen. Our first webinar took place back on the 23rd of April, and the articles emanating from that webinar were published in our May newsletter, which is still available for you to read at your leisure. The link for which I hope you will see Lisa from our marketing team is just putting into the chat function now. Similarly, the content of this webinar, in addition to it being recorded and put on our 3PB website within the next few days, will be available for you to read in greater detail in our June newsletter, which will be published tomorrow and which will contain many other interesting articles and bits of information from us and other members of the team, which we hope you will find useful. So, over the course of the next hour, Sarah and I will be discussing recent updates to the coronavirus job retention scheme, the second Treasury direction, health and safety and whistleblowing issues arising from workers and employees starting to return to work, changing employees' terms and conditions, and consultation requirements for collective redundancies. Now, whilst we've sought to incorporate the answers to questions many of you have submitted to us prior to today, we will try and answer any further questions from you that you can put into the chat box as we go along, if we get time at the end. So, good afternoon, SJB.
Good afternoon, Craig.
Now, we know that the coronavirus job retention scheme will remain open until the end of October, but can you tell us about what was announced by the Chancellor on Friday?
Well, at the 11th hour on Friday afternoon, as usual, the Chancellor announced that from the 1st of July, which was a month earlier than previously announced, employers can bring back to work employees that have previously been furloughed for any amount of time and any shift pattern, while still being able to claim the scheme grant for their normal hours not worked. Employers will have to pay their full wages whilst they're working. When claiming the scheme grant for furloughed hours, employers will need to report and claim for a minimum period of a week. The scheme will close to new entrants from the 30th of June. From that point onwards, employers will only be able to furlough employees if they have furloughed for a full 3-week period prior to the 30th of June. This means that the final date by which an employer can furlough an employee for the first time will be the 10th of June, in order for the 3-week furlough period to be completed by the 30th. So employers will have until the 31st of July to make any claims in respect of the period to the 30th of June, and further guidance on flexible furloughing and how employers should calculate claims will be published on the 12th of June.
So what do the scheme updates mean as far as the amounts of grant which can be claimed, and what contributions will employers have to make?
So for June and July, the government will pay 80% of wages up to the cap of £2,500, as well as employer national insurance and pension contributions. Employers are not required to pay anything. Then in August, the government will pay 80% of wages up to the cap of £2,500. They will pay national insurance and pension contributions for the average claim. That represents about 5% of the gross employment costs of the employer would have incurred had the employee not been furloughed. Then in September, the government will pay 70% of wages up to a cap of £2,187.50. Employers will pay the employer national insurance and pension contributions and 10% of wages to make up the 80%, up to a cap of £2,500. For the average claim, this represents 14% of the gross employment costs of the employer, that the employer would have incurred had the employee not been furloughed. Then finally, in October, the government will pay 60% of wages up to a cap of £1,875. Employers will pay the employer's NI and pension contributions and 20% of wages to make up 80% total, up to the cap again of £2,500. For the average claim, this represents 23% of gross employment costs. So, Craig, there's been a second Treasury direction issued, hasn't there?
Yes, a new Treasury direction for the scheme was published on the 22nd of May. It amends and effectively replaces the first Treasury direction issued in relation to claims made on or after that date, or in relation to earlier claims that would have been compliant with the second Treasury direction in any event until the 30th of June. So the second Treasury direction will apply to the furlough period from the date of the last claim an employer made under the first direction. And that means that some periods of furlough which occurred prior to the publication of the second direction will be determined on its terms, even though the employer could not have been aware of its terms at that time.
And so what, if any, changes has the second Treasury direction introduced?
Well, generally the second direction addresses some discrepancies between the first direction and HMRC's guidance, but there's one major amendment. So I'm going to highlight 8 points. Firstly, the major amendment is that the new wording on the form of agreement required to replace an employee on furlough removes the explicit requirement in the original Treasury direction that an agreement must be in writing. Secondly, employers are required to retain the agreement or confirmation until at least 30th of June 2025. And I think we can assume safely that a further direction will be issued in due course, extending that until October 2025. Thirdly, there's new detailed guidance on the kinds of study and training that an employee can do whilst on furlough without breaching the requirement that a furloughed employee do no work for the employer. Fourthly, pension scheme trustees are specifically allowed to continue to do work for the sole purpose of fulfilling their duties. Fifthly, where SSP is in payment or due to be paid, furlough cannot begin until immediately after the end of the period of incapacity for work for which the SSP is being paid or due to be paid. The sixth point I want to make is that details are provided of how the scheme applies to employees on unpaid leave. Seventh point in relation to pay, regular pay means that cannot vary according to a relevant matter except where the variation in the amount arises from a non-discretionary payment. So relevant matter for this purpose is defined to include business performance, the employee's contribution, the employee's performance of his or her duties, and any similar considerations or otherwise payable at the discretion of the employer or any other person, such as a gratuity. And variations arising from non-discretionary payment covers payments such as overtime, fees, commission or piece rates, payments made in recognition of the employee undertaking additional or exceptional responsibilities, and other similar matters. And the last point about the second direction, employers do not need to make a payment to employees before claiming reimbursement from the scheme, provided they intend to pay employees within a reasonable time of receipt. So in terms of SSP then, Sarah, have there been any updates?
Yes, there have. Entitlement to statutory sick pay has been extended under the Statutory Sick Pay Coronavirus Amendment number 4, Regulations 2020, to people who have been told to isolate under the new test and trace system, which started in England, as we know, on the 28th of May. Accordingly, a person who has been notified that they have had contact with a person with coronavirus and who is self-isolating for 14 days as a result will be entitled to statutory sick pay. Now, annual leave. What's the present position, Craig, on annual leave for employees and workers?
So this was an area of some debate between various legal commentators when the guidance originally came out, but the position now is that workers who have been placed on furlough continue to accrue statutory holiday entitlements and any additional holiday provided for under their employment contract. So employers can require workers to take holiday and cancel a worker's holiday if they have given sufficient notice to the worker. And the required notice periods in order to do, that is to say, to require workers to take holiday or cancel a worker's holiday, are double the length of the holiday if the employer wishes to require a worker to take holiday on particular days, the length of the planned holiday if the employer wishes to cancel a worker's holiday or require the worker not to take holiday on particular dates. So employers can ask workers to take or cancel holiday with less notice, but they would need the worker's agreement to do so, and ideally in writing. Workers on furlough can take holiday without disrupting their furlough, but the notice requirements still apply. And if an employer requires a worker to take holiday whilst on furlough, the employer should consider whether any restrictions the worker is under, such as the need to socially distance or self-isolate, would prevent the worker from resting, relaxing and enjoying leisure time, which is the fundamental purpose of holiday.
So how about still being able to carry forward annual leave?
So to protect workers from losing their statutory holiday entitlement, as people watching will be aware, the government previously passed the Working Time Coronavirus Amendment Regulations 2020. These regulations stated that where it has not been reasonably practicable for the worker to take some or all of the 4 weeks holiday due to the effects of coronavirus, the untaken amount may be carried forward into the following 2 leave years. So when considering whether it was reasonably practicable for a worker to take leave as a result of coronavirus, so that they may carry untaken holiday into future leave years, an employer should consider various factors, such as, I'm going to spell out 6 factors: whether the business has faced a significant increase in demand due to coronavirus that would reasonably require the worker to continue to be at work and cannot be met through alternative practical measures. Secondly, the extent to which the business workforce is disrupted by the coronavirus and the practical options available to the business to provide temporary cover of essential activities. The third point, the health of the worker and how soon they need to take a period of rest and relaxation. Fourth factor, the length of time remaining in the worker's leave year to enable the worker to take holiday at a later date within the leave year. The extent to which the worker taking leave would impact on wider society's response to and recovery from the coronavirus situation. And finally, the final factor to take into account is the ability of the remainder of the available workforce to provide cover for the worker going on leave. So, in short, employers should do everything reasonably practicable to ensure that the worker is able to take as much of their leave as possible in the year to which it relates. And where leave is carried forward, it's going to be best practice to give workers the opportunity to take holiday at the earlier practicable opportunity.
So what about furloughed workers then, Craig?
So the government guidance states that workers who are on furlough are unlikely to need to carry forward statutory annual leave, as they'll be able to take it during the furlough period. However, to do so, they must be paid the correct holiday pay, which is likely to be higher than the rate of pay that will be covered by the government grants, with the employer having to make up the difference. So at this time, the 20%. But if due to the impact of coronavirus on operations, the employer is unable to fund the difference, it's likely that this would make it not reasonably practicable for the workers to take their leave, enabling the worker to carry their annual leave forwards. So in that situation, the worker must still be given the opportunity to take their annual leave at the correct holiday pay before the carried annual leave is lost at the end of the next 2 years.
Right, now to slightly change topic, terms and conditions. So employees are starting to return to work with the easing of lockdown, be that on a part-time basis or otherwise. Employers are continuing to assess the viability of their business as a going concern. How might employers make changes to an employee's contractual terms lawfully in order to avoid redundancies, for instance, agreeing to a reduction in wages?
Well, in answering that question, I think it's important at the outset to make the general points that if a contract of employment does not authorise the employer to change the employee's terms, the employer really has four options. One, obtaining express agreement from the employee. Two, relying on implied agreement to the purported change. Three, unilaterally imposing the change and relying on implied agreement. Or fourthly, terminating the employment and offering to re-engage on new terms. In relation to obtaining express or implied agreement, the two key legal principles of consent and consideration must be borne in mind, because without either of those being present, any change that is purported to be made by an employer to an employee's contractual terms is highly likely to be held to be unlawful. So consent can be obtained by either an employee's express or implied agreement to a proposed change of his or her contractual terms. And the best evidence of express consent is to obtain something in writing to that effect from the employee. In addition, express consent can be obtained through a collective agreement, for instance, where a recognised union is involved, where an employee's contract expressly states that his or her terms and conditions can be changed by agreement at collective level.
So before we move on to implied consent, what are the consequences if agreement to reduce pay cannot be reached?
Well, if an employer attempts to obtain express agreement to a reduction in pay but is unable to do so, then two options are impose the change and rely on the employee's implied agreement to that change, or secondly, terminate the existing contract and offer continued employment on new terms. But terminating the contracts and offering continued employment on new terms, it's important to bear in mind that depending upon how many people it's proposed to terminate their contracts and then re-engage on different terms, the proposed dismissals may count as redundancies under the Trade Union and Labour Relations Consolidation Act 1992. We'll come back to that point again when we discuss consultation and collective redundancies. The second point to bear in mind is that could be wrongful dismissal if the employer fails to serve the required contractual notice. And third point, obviously, is claims of unfair dismissal, albeit employers are likely to want to rely on the potentially fair reason for dismissal of some other substantial reason.
Okay, so implied consent is a legal minefield, isn't it? How might it be established?
Yes, so in answer to that question, it is a minefield. Cases involving implied consent are usually very fact-specific and fact-dependent as to what is required to evidence implied consent. What I think can be distilled by way of general guidance from the case law is that when an employer purports to impose a change to an employee's contract, if the following three criteria are satisfied, implied consent may be inferred by a court or tribunal, and the purported variation may be lawful if, so firstly, the employee continues to work for a significant period of time. Secondly, he or she does so without protest, and that's either individually or collectively. And thirdly, whilst continuing to work, the employee is aware of the purported change being imposed by the employer. And whilst there are only a small number of authorities in which the courts or the EAT have had to consider whether employees have become disentitled to enforce the terms of a contract of employment because they failed to object to a purported variation, the seminal case that people should be aware of dealing with implied consent is the Court of Appeal case of Abrahol and Nottingham City Council. The case references, I should say, as we go through, will all be in the articles emanate or set out in the newsletter that will be published tomorrow. So don't worry too much about those. So the Aberhall case was a case in which Lord Justice Underhill helpfully reviewed all the relevant authorities, and it's been held that the fundamental question to ask in cases where employees continue to work in circumstances where the employer has purported to effect the change is, and I quote, whether the employee's conduct by continuing to work is only referable to his having accepted the new terms imposed by the employer. If it is, then the purported change is likely to be effective. But if it is not, and there is evidence that his continuing to work is referable to other reasons, then it may not be effective. And I think it's helpful just to set out some comments made by the Court of Appeal in Aberhall in relation to cases where the issue of whether or not complied consent should be inferred by courts dealing with purported contractual variations. So firstly, if the conduct of the employee in continuing to work is reasonably capable of a different explanation, it cannot be treated as constituting acceptance of the new terms. It is not right to infer that an employee has agreed to a significant diminution in his or her rights unless their conduct, viewed objectively, clearly evinces an intention to do so. So to put that another way, the employees should have the benefit of the doubt. Secondly, protest or objection at the collective level may be sufficient to negative any inference that by continuing to work, individual employees are accepting a reduction in their contractual entitlement to pay, even if they themselves say nothing. And thirdly, it is easy to see how it may not, depending on the circumstances of the particular case, be right to infer acceptance of a contractual pay cut as from the day that it is first implemented. The employee may be simply taking some time to think, but a time may come when that ceases to be a reasonable explanation. And finally, on this point, don't forget to give consideration for the purported change. So whilst at the present time it may well be that offering to furlough employees rather than dismissing them for redundancy is enough by way of consideration, ordinarily courts and tribunals would expect something more by way of consideration, i.e. a one-off payment of a sum of money.
So that's changing terms and conditions. The other really significant issue that's going to come right to the forefront for employment lawyers is collective consultation and redundancies. Sorry, consultation and collective redundancies. Where can the statutory framework be found for dealing with consultation in relation to collective redundancies, Craig?
Yes, well, this is going to be very much a whistle-stop tour through the very complex issue of consultation collective redundancies. And before I answer your question, Sarah, I think it's important to recognise that there will be a lot of smaller businesses or even medium-sized businesses will be considering dismissing by reason of redundancy between 1 and 19 employees. And so consultation still needs to be considered in the context of the reasonableness test in section 98(4) of the Employment Rights Act and the principles set down in the Williams and Compare Maxim case that I'm sure people will be familiar with watching this webinar. But in answer to your question, the statutory duty on employers to inform and consult their workforces about proposed redundancies is set out in section 188 of the Trade Union and Labour Relations Consolidation Act 1992. I hope that is now up on your screen so that as I talk to this section, you can see what I'm talking about. And I should say, it's important to point out that the Coronavirus Job Retention Scheme makes clear that collective consultation obligations are not altered by the scheme. So it's important that obviously this section is considered. So as you'll see from section 188 subsection 1, Where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, the employer shall consult about the dismissals all the persons who are appropriate representatives of any of the employees who may be affected by the proposed dismissals or may be affected by measures taken in connection with those dismissals.
Does an employer need to consult with fixed-term employees?
So that's a discrete point, but fixed-term employees are excluded from an employer's duty to consult on collective redundancies under Section 188 unless the employer is proposing to dismiss the employee as redundant before the expiry of the term, the completion of the particular task, or the occurrence or non-occurrence of the specific event.
What does proposing to dismiss actually mean?
Yes, so going back to Section 188, and if I can ask Lisa again to put that up on the screen for us, please. I think whilst Lisa's doing that, it's important to note there is a disparity between the wording of the 1992 Act and the EU Collective Redundancies Directive. So whilst the 1992 Act imposes a duty to consult at the point that an employer proposes collective redundancies, the directive requires consultation where an employer is contemplating collective redundancies, i.e. arguably an earlier point in the process in time. So that issue came for consideration before the ECJ in the case of Junk and Connell, where the ECJ stated that the case in which the employer is contemplating collective redundancies and has drawn up a project to that end corresponds to a situation in which no decision has yet been taken. By contrast, the notification to a worker that his or her contract of employment has been terminated is the expression of a decision to sever the employment relationship, and the actual cessation of that relationship on the expiry of the period of notice is no more than the effect of that decision. Now, domestically, in the case of UK Coal Mining Limited and National Union of Mine Workers, the then president of the EAT, President Elias, considered all of the relevant authorities, including the Junk case that I've just spoken to, and he held that in a closure context, where it is recognised that dismissals will inevitably or almost inevitably result from the closure, dismissals are proposed at the point when the closure is proposed. The difference between proposed and contemplated will still impact on the point at which the duty to consult arises. It will not be when the closure is mooted as a possibility, but only when it is fixed as a clear, albeit provisional intention. And I think domestically, that is where you should derive your advice to your clients if you're advising either employer or employees. That's the UK coal mining case. That said, the ECJ did revisit that issue in a case called Akavan and Fujitsu, where it held, assessing the contemplation aspect rather than proposing to dismiss. The ECJ said the consultation procedure must be started by the employer once a strategic or commercial decision compelling him to contemplate or to plan for collective redundancies has been taken.
Is there a difference between the definition of redundancy between individual claims for redundancy payments or unfair dismissal claims pursuant to Section 139 of the Employment Rights Act and redundancy for the purposes of collective consultation purposes under the 92 Act?
So the answer to that is yes. Pursuant to Section 195, subsection 1 of the 92 Act that I hope is on your screens now. Yes, I can see it. The definition of redundancy for collective consultation purposes differs significantly from the Section 139 Employment Rights Act definition. As you'll see from your screen, Section 1951 provides that references to dismissal as redundant are references to dismissal for a reason not related to the individual concerned or for a number of reasons all of which are not so related. So the implications of that difference in definition between individual and collective redundancy is potentially important, as, for example, if an employer wishes to introduce a change in terms and conditions but cannot obtain the agreement of employees to the change, the normal course is to terminate their existing contracts of employment, reissue new ones or issue new ones, incorporating the required variation. Those facts would be unlikely to fall within the Employment Rights Act definition of redundancy, and so would not give rise to statutory redundancy payments, albeit they might give rise to unfair dismissal claims. But under the section 195 definition that we're looking at on the screen, such dismissals not being related to the individuals concerned would trigger the section 188 statutory consultation procedure, requiring the employer to negotiate with the appropriate representatives of the employees with a view to reaching an agreement before imposing the new contracts. So to put that in context, there's a case in the EAT called GMB and Man Truck and Bus UK Limited, and the employer gave employees notice of dismissal and then offered to re-engage them on new terms. And the EAT held that the duty to consult applied, despite the fact that the employer never intended the employees to lose their jobs and that the employees continued to work uninterrupted throughout.
Craig, are there minimum statutory consultation periods for collective redundancies?
Yes. So again, if we can have section 188 back up on the screen, please, and specifically subsection 1A, you'll see that the consultation shall begin in good time. We'll come back to that phrase in a moment. And in any event, where the employer is proposing to dismiss 100 or more employees at least 45 days, and otherwise at least 30 days, before the first of the dismissals takes effect.
So what does in good time actually mean?
Well, that phrase derives from the EU Collective Redundancies Directive, and which itself doesn't lay down any specific time limits. But in the case of Amicus and Nissan Motor Manufacturing UK Limited, the employer informed the elected employee representatives on the Staff Council on the 1st of October 2003 of its plan to relocate its purchasing services department from Sunderland to Bedfordshire on the 1st of June 2004, so circa 8 months in advance. And the employer required the 62 employees to indicate by the end of January 2004 whether they were prepared to move to Bedfordshire. However, consultation with the union representatives did not begin until the 19th of January 2004. So in dismissing the employer's appeal, the AT accepted that good time means no more and no less than time sufficient for fair consultation to take place, working back from the final date, which is the first date for dismissal. One cannot adopt a too mechanistic or arithmetical approach to working out what is or is not good time. It will depend on many factors and is essentially a question for the tribunal. The important question was, notwithstanding the fact that the union officials did not become involved until either the end of December or beginning of January, was there still good and sufficient time for, and this is the key phrase, fair and meaningful consultation to take place before the effective date of dismissal?
So what does Act 1, what does Act 1 establishment mean?
So the leading European cases on the definition of Act 1 establishment is Rockfon and Denmark, and a case called Athenaki. And basically, between the two of them, the European Court of Justice held that, firstly, the term establishment is to be defined broadly. Secondly, an establishment in the context of an undertaking may consist of a distinct entity having a certain degree of permanence and stability, which is assigned to perform one or more given tasks, and which has a workforce, technical means, and a certain organisational structure allowing for the accomplishment of those tasks. Thirdly, the entity in question need not have any legal, economic, financial, administrative or technological autonomy in order to be regarded as an establishment. And finally, it's not essential for the unit in question to be endowed with a management that can independently effect collective redundancies in order for it to be regarded as an establishment. But domestically, the EAT is held in a case called Seahorse Maritime and Nautilus International. The establishment may not be a physical unit. It could be an organisational unit in a service industry set up to provide a certain type of labour or to provide labour at a particular location. The operator may not own or operate the unit, such as one providing catering services to a particular organisation or at a particular building. The relevant establishment will be the unit within the employer's organisation to which the employees are assigned, not that of the client for whom their employer provides services. And in that context, I've just briefly mentioned the case of Usdaw and another, and Ethel Austin, otherwise known as the Woolworths case, which in a nutshell found that each establishment, or each store rather, was a discrete establishment.
So what should the consultation include?
So that is dealt with at section 1882. If Lisa, I could ask you to put that up on the screen again, please. And so you'll see there that consultation must include consultation about A, avoiding the dismissals, B, reducing the numbers of employees to be dismissed, and C, mitigating the consequences of the dismissals, and should be undertaken by the employer with a view to reaching agreement with the appropriate representatives. So I think it's important to bear in mind that these three factors, A to C, must be treated independently. So employers must consult on each factor, else they'll potentially be in breach of section 188 if they do not consult on one of them. And whilst the last requirement, in terms of with a view to reaching an agreement, doesn't mean that the parties have to reach an agreement, as ultimately the final decision on redundancies is a matter for the employer alone. The obligation on the employer to consult, though, is absolute, and to do so meaningfully. And if an employer is found to be simply going through the motions of consultation, they're likely to be found to be in breach of section 188.
So how does an employer determine the numbers of redundancies which are required to be included for the purpose of engaging section 188? So
that's dealt with at subsection 3 of section 188. I think that's still on your screens, which you can see says, in determining how many employees an employer is proposing to dismiss as redundant, no account should be taken of employees in respect of whose proposed dismissals consultation has already begun. So to give two examples, if an employer is already consulting on 60 proposed redundancies and then a further 40 redundancies are proposed a week later, pursuant to the strict application of section 188.3, an employer would not need to add the two groups together to mean that there was a minimum 45-day consultation period rather than a 30-day minimum period for each. However, if both of the aforementioned groups of redundancies were proposed within a 90-day period, the question then becomes whether an employer was just staggering the redundancies so as to avoid its longer collective consultation requirements. And I think it's right to say that a court or tribunal will look behind that apparent staggering to ascertain whether in fact the employer had in fact proposed to dismiss 100 employees at the same time.
So when can the dismissal notices be sent out to employees?
Well, that issue was dealt with in the case of TGWU and Ledbury Preserves, where the EAT said there must be sufficient meaningful consultation, that phrase again, meaningful consultation, before notices of dismissal are sent out. The consultation must not be a sham exercise. There must be time for the union reps who are consulted to consider properly the proposals that are being put to them.
Now, is there any defence available to an employer who fails to consult in accordance with Section 188 of the 92 Act?
Yes, so this is a subject area for a webinar in itself. So in terms of the time we've got available to us, I'm quickly going to go through or look at Section 1887, which I can see is on your screens now, and that provides for a special circumstances defence. And you'll see there that if any case where there are special circumstances which render it not reasonably practicable for the employer to comply with the requirements of subsections 1A, 2 or 4, the employer shall take all such steps towards compliance with that requirement as are reasonably practicable in those circumstances. But somewhat unhelpfully, you might think, there's no definition of special circumstances contained in the Act, but in the Court of Appeal case of Clerks of Hove Limited and Bakers Union, it was held that special circumstances means, and I quote, to be special, the event must be something out of the ordinary, something uncommon, and that is the meaning of the word special in the context of this Act. So I think moving on, Sarah, to the next question, for the sake of time.
Yeah, how might COVID-19 be dealt with by the courts and tribunals when employers inevitably put it forward as a special circumstance?
So as well as needing to show that the circumstances are special, which on the Bakers Union definition it's likely to be, employers will still need to show that compliance was not reasonably practicable. So the effect of the pandemic may mean that there are practical difficulties with appointing representatives in the normal way and undertaking full consultation, and also in terms of remaining solvent while the process is undertaken. However, I think it's more than arguable that the employers can conduct meaningful collective consultation remotely if the facilities are in place to do so, which of course they're required to provide access to the employee representatives in accordance with the 1992 Act. Sarah, do you want to deal with the insolvency issue as far as special circumstances concerned?
Sure. So the Court of Appeal has dealt with that very question in the Bakers Union case and held that insolvency is on its own neither here nor there. It may be a special circumstance, it may not be a special circumstance. It will depend entirely on the cause of the insolvency, whether the circumstances can be described as special or not. If, for example, sudden disaster strikes a company making it necessary to close the concern, then plainly that would be a matter which was capable of being a special circumstance. If the insolvency was merely due to a gradual rundown of the company, as it was in this case, then those are facts can come to the conclusion that the circumstances were not special. So can special circumstances that occur after the obligation to consult excuse an earlier failure to comply, Craig?
So the short answer is no. I go into far more detail about this in the article that will come out with tomorrow's newsletter. But the relevant case for that principle, that answer I've just given very shortly is no, is the Keeping Kids Company in compulsory liquidation and Smith and others.
So if special circumstances are proved, do these absolve an employer from complying with the consultation requirements in respect of which compliance was reasonably practicable or which were not affected by the special circumstances?
Again, no. Pursuant to the case of Shanahan Engineering Limited and Unite the Union, where the EAT held that although special circumstances relieve the employer of the obligation to undertake the full 30-day consultation over collective redundancies, it should still have made some attempt at consultation. So, Sarah, with the time we have left, can we turn to a different topic, and that's health and safety and whistleblowing issues?
Sure. I think It's first very useful to remind ourselves the context in which we're now considering health and safety matters with the easing of lockdown. So obviously on the 23rd of March, non-essential businesses and premises were closed. On the 11th of May, the government announced the easing of lockdown measures and published our plan to rebuild, which is the recovery strategy. This permits the phased opening of non-essential businesses and premises from the 1st of June. From the 13th of May, many employees were then advised to follow the Covid-19 secure guidelines, which deal with health and safety matters.
And so what are the 5 steps to working safely published by the government?
So to support the opening or reopening, as it may be, of businesses and premises, the government has published 5 steps to working safely, which provides practical solutions for businesses to take. These basic 5 steps sit along the working safely during COVID-19 guidance that is relevant to a particular workplace, which I will refer to as the secure guidelines in this talk. Employers must implement the 5 key steps as soon as practicable, and they are: firstly, carry out a COVID-19 risk assessment; 2, develop cleaning, hand washing and hygiene procedures; 3, take all reasonable steps to help people work from home, which is the primary position; 4, where possible, maintain 2 metres between people; and 5, where that 2 metres isn't possible, they should do everything practical to manage the transmission risk.
And so what are the COVID-19 secure guidelines working safely about then?
So the COVID secure guidelines have been published to try and make workplaces less infectious. They're addressed to employers, employees and self-employed. They're the accumulation of a combined effort by the Department for Business, Energy and Industrial Strategy, firms, unions, industry bodies, devolved administrations in Wales, Scotland and Northern Ireland, Public Health England, the Health and Safety Executive. And it's important to note that public health is devolved, of course, for Northern Ireland, Scotland and Wales. Therefore, all practitioners, employees and employers should check the guidance in the applicable region before advising. And of course, they will issue their own guidance alongside the public health and safety requirements that are being published by the government. So the secure guidelines currently apply to 8 workplace settings, but it's likely that one employer might need to apply more than one version of the guidelines. The 8 settings are offices and contact centres, shops and branches, factories, plants and warehouses, labs and research facilities, construction and other outdoor work, other people's homes, for carers for example, restaurants offering takeaway or delivery, and then finally vehicles, so taxi drivers, that sort of thing. The guidelines apply to businesses that are currently open and for those that will be reopening from the 1st of June. There's a significant amount of overlap in the 8 documents. Combined, they're about 230 pages, but they have all been individually carved to give advice to the 8 workplaces.
And how should the secure guidelines be used then?
So, as I said, the primary position is staff should be working from home. The secure guidelines consider steps that an employer should take in relation to each of the 8 workplace settings. The common aspects of advice relate to risk, who can return to work, PPE, face covering, social distancing at work, travel and accidents. They provide the bespoke practical considerations, for example, advice on dealing with customers, visitors and contractors. Each business is advised to translate those guidelines, though, into the specific actions it needs to take for its own workforce, depending on the nature of the business, its size and type, how it's organised, operated, managed and regulated. The secure guidance is not mandatory. It's not a set of legal requirements set in stone to enable a return to work, and it doesn't supersede any legal obligation relating to health and safety, employment or equalities law. But not following the guidance is very likely to be taken into account if an employer is alleged to have failed in compliance of their legal obligations.
And in practical terms, what do the guidelines say about managing the risk?
So as I said, it's about 250 pages across the sectors. To just refer to an example from the offices and contact centres guidance and how they make recommendations about social distancing and workstations. Some of the examples are reviewing layouts of offices to allow people to work further away from each other, where it's not possible to move workstations further apart. If that's not possible, use screens. People shouldn't be working face to face, but side by side. Managing the number of staff in an office, avoiding the use of hot desks and rotation of staff, and sanitising any desks or communal areas thoroughly. Under the shops and branches guidance, and of course we'll all have been to a supermarket during lockdown, somewhat reluctantly perhaps. If you go to Waitrose or Boots or Sainsbury's, etc., other retailers are available, then obviously you'll see that they're limiting the number of customers in the store. They're encouraging customers to use hand sanitizer, hand washing facilities, encouraging customers to avoid handling products whilst browsing, if at all possible.
Now, there's been a lot of debate about PPE in the press, and it's become exceptionally difficult to get your hands on any. So what do the secure guidelines say about that topic, PPE?
Yeah, likely to be a big issue in the workplace. Secure guidelines state that where PPE is already used in the work activity to protect against non-COVID risks, it should continue to be used. So, for example, a clinical setting. But employers outside of that should not encourage the use of PPE outside of clinical settings. And unless employers are in a situation where the risk of COVID-19 transmission is very high, their risk assessment should reflect the fact that the role of PPE in providing additional protection is actually extremely limited. Of course, this is all based on government guidance. If the risk assessment shows that PPE is required, then employers have the obligation to provide that free of charge, and it must fit properly. Although PPE is not being recommended outside of the clinical settings, there's been a bit of a debate, obviously, about the use of face coverings as well. And of course, it's now become quite tricky to buy a sewing machine because of this. But the secure guidelines also address face coverings, which are described as, quote, marginally beneficial as a precautionary measure. So it's currently optional, not required by law, including in the workplace, but employers are advised in the guidance to support their workers if they choose to use a face covering, which means effectively educating and advising them on how to maintain good hygiene and safety in respect of the same.
Okay, so a lot of people seem to want to wear it anyway. Can an employer take action if an employee wears their PPE to work?
Well, even if it's not necessary, it's possible that, of course, as you say, employees might want to wear it anyway, and that could vary from snorkel masks, which I've actually seen walking around London, face masks, or another variable. The guidance actually says that they should be supported if they want to wear it, but legally, of course, if an employee in circumstances of danger that they reasonably believe to be serious and imminent takes appropriate steps to protect themselves or others from that danger, they are protected against dismissal, which would be automatically unfair under Section 101E of the Employment Rights Act, and detriment under the equivalent provision under Section 44 of the Employment Rights Act. Many, many technical arguments are going to rise over this. So, in short, if an employer does take any negative action, in my view, they probably need to be a bit careful about it.
All right. Now, Sarah, I know you've got a lot more that you would like to tell us about sections 44 and section 100, generally about health and safety and whistleblowing issues. And you've produced an article that will come out in tomorrow's newsletter that deals with that further information. But I think we've got 5 minutes remaining. I'd like to ask you, if I can, about the webinar that I know both you and I attended this morning that was given by the new president of the Employment Tribunals for England and Wales, Barry Clark. And can I ask you about your views as to both what came out in writing yesterday by way of further instruction or amendment to the FAQs, and what he said this morning as to how that relates to practitioners, how cases are going to be dealt with?
That's certainly great. I mean, so last night the updated FAQs document was published. I don't know if Lisa, if it's the last document on your list, if you can perhaps share that on your screen. So the Employment Tribunals in England, Wales and Scotland FAQs came out in the appendix. There is the roadmap. The idea is obviously to get the tribunals running again, and this is the plan. It's contingent on quite a few things. Two sticking points appear to be not only obviously in the context of dealing with a pandemic, so it's unpredictable. We don't know if there are going to be spikes in different regions. We don't know if we're going to be able to actually attend court buildings, whether they'll be open. But the President made very clear that facilities need to be there in terms of buildings. They need judges that are trained on CVP, which is obviously the platform that the tribunals are going to use, and they need the administrative staff in order to actually support that function. I understand that one member of staff needs to be available to clerk each video hearing on CVP. So the idea is, and just to quote the President, he described that he's been at the helm, obviously, for a few weeks now. It was a learning cliff, he said. The pandemic had been an accelerant and a disruptor to tribunal proceedings. And he relied on the following quote: decades when nothing happens, and then weeks when decades happen, and that the route had been taught to us to get to the stage that they're at. I think they've really struggled, but they're doing incredibly well in trying to move forward. So they are from July going to try and, well, in fact, sorry, from June going to use CVP increasingly for hearings. The type of hearings is going to be relatively limited. They've got some priority hearings already that they're using video platforms for, and looking at the FAQs that are now out, that will include statutory appeals against prohibition notices, interim relief applications, dismissals where an individual's lost accommodation, and then Covid-19 pandemic related claims alleging detriment or dismissal on health and safety or protected disclosure grounds under section 43B, 44, 47B, 100 and 103A of the Employment Rights Act. So they're the priority hearings. Unfair dismissal cases are going to start to be heard by CVP by August time, certainly. It looks though like the more complex trials involving discrimination and whistleblowing may not go to CVP quite so quickly, although they don't say that they definitely won't, and he's made it quite clear in my interpretation of what was said that it depends on the regions. The regions that have already been trialling the platform are very likely to get up to speed more quickly than others. And actually, he's accepted that there is very likely to be inconsistency between how the various regions are able to deal with cases. So that is the lesser evil, though, than completely ceasing to service employment tribunal claims, which is seen as the lesser, the greater disadvantage.
So just finishing off that, Sarah, then, it doesn't sound like any discrimination and whistleblowing cases until beginning of September?
Well, it's quite interesting, isn't it? Because it says it's not likely. And it's obviously going to be under constant review. So it probably isn't likely. Whether they definitely don't go ahead, I don't know. I mean, I was certainly offered a discrimination case in London by video of 3 days in length. I'm aware of other cases where they're now making inquiries about whether complex cases are suitable for video platform. So I think it's going to be a case of waiting to see what happens, but of course the parties are still able to make an application at any time if they want the tribunal to deal with the case in a particular way.
Yes. All right, thank you very much, Sarah. Well, that concludes our second COVID-19 webinar, and so it just leaves me to say thank you very much on behalf of myself and Sarah for virtually attending today. We hope that you found it useful. Please do look out for our newsletter, which will be published tomorrow, and our forthcoming webinar programme, in which many other members of the employment team will be providing their thoughts on a variety of topics and cases. And we look forward to seeing you again in the future. Good afternoon.